From the PEP Radio Newsroom, this is the news blast for the lunch hour of March 25th, 2025. Some good news from the Pennsylvania Supreme Court. Before March 20th, Pennsylvania parents had four options for establishing parentage, the process by which a child's parents are legally identified and defined. The only pathways were through biological connection, adoption, presumptions based on marriage and conduct, and contracts. Some of these definitions might seem obvious, like biological parents, but families are developed in all sorts of ways. This is especially true for LGBTQ plus parents, whose family planning often involves more steps. For instance, non-gestational parents who use assisted reproductive technology, or ART, or surrogacy often choose to establish parentage via contract during pregnancies and/or adopt those children after they're born. But what happens if no contract is signed and parents split up before a child's birth? What happens in a parentage dispute? This was the problem at the crux of Glover v. Jr., a lawsuit through which Nicole Jr. sought parental rights regarding a child who was conceived during a marriage but born during a separation. The Pennsylvania Supreme Court first heard oral arguments for the case in September 2024, and they finally issued a ruling. We believe the time has come for our law to embrace a fifth pathway to parentage, reads the 54-page decision, which establishes a precedent in the state of Pennsylvania for intent-based parentage. This new legal framework now extends parental rights to those who lack other paths towards parentage, but can demonstrate their intentions. What does it mean to show intention? Court documents outline Junior's intent-based claims, including that she was heavily involved in conception by sharing the associated costs and injecting Chanel Glover with hormones throughout the months leading up to the conception and after. The former couple also attended obstetrics appointments together and entered into a joint contract with a doula. They signed a contract in anticipation of Junior's confirmatory second parent adoption of the child, a process that cannot officially begin until a child is born, and picked out a name for the child, which was to be hyphenated to reflect both parents. As their relationship deteriorated, Glover stopped involving Junior in her prenatal care and planning, but Junior quickly attempted to reestablish pre-birth parentage through the family courts system. That court ruled in her favor just weeks before the birth. Glover appealed, sending the case to trial. The court sided with Junior, citing parentage by contract, giving the agreements the former couple entered before their falling out. But on appeal, a three-judge panel on the Superior Court disagreed. Junior attempted to re-argue the case, claiming parentage by marital presumption. But because the pair was no longer a couple when the child was born, it was not granted. Throughout 3 years of litigation, Junior never got to see or meet her child. But on March 20th, the Pennsylvania Supreme Court decided that the contracts entered before and during pregnancy and the behavior of both parties in their efforts to get pregnant and before their falling out demonstrated that both Glover and Junior's intended for Junior to show parenting rights. Junior's lawyer told the Philadelphia Inquirer that she aims to pursue custody arrangements in family court as soon as possible. That's our news blast. If you're watching our news reports on the PEP Radio channel on YouTube, be sure to click the subscribe button. Up next is the National Weather Service forecast for the Meadville area, right here on PEP Radio.